When I was interrupted with my contribution earlier, I was stressing the point that I was notified to do jury duty, or expected to do jury duty, and unfortunately with my employment history, including my current duties as a Member of Parliament, I'm unable to do jury duty, so I've been exempted from it. And in my previous jobs, such as the Secretary of the Union and then as a paramedic, I was unable to do it, but I would have loved to have been able to, I believe, contribute to be able to do some jury duty, and I expect that my constituents, but also community members in general, would participate in the process of doing jury duty. I think it's an obligation of ours. Look, the courts are also facing, we know, large backlogs of criminal jury trials because of the challenges that we've faced over these last 2 years due to COVID, and it's appropriate to reintroduce judge-alone trials as a temporary measure to give the courts an additional option to continue to hear criminal trials alongside jury trials, and to help them drive down the COVID backlog. And allowing the courts to order trials by judge alone will give the courts and parties an alternative to jury trials in appropriate cases, and allow more criminal trials to run. And this will reduce delays in the court system and benefit all parties. Look, the court can order a trial by judge alone for an indictable Victorian offence if the following criteria are satisfied, and that is the accused person consents to be tried by a judge alone, the court is satisfied the accused has sought and received legal advice on whether to consent to a judge alone trial, and the court is satisfied it is in the interest of justice to order a judge alone trial. I want to make some reference to the youth justice system, and from the beginning of this pandemic, limiting the spread of the COVID-19 in our custodial facilities has been of the highest priority. But this has not been easy. COVID-19 has continued to present significant challenges in youth justice operations and service delivery. And despite all of those challenges, youth justice facilities at Parkville and Malmesbury have remained operational, and community supervision has continued through adapted modes of delivery. And at the commencement of the pandemic, youth justice rapidly scaled up its technology capability in custody and the availability of audio-visual links to the courts. And I think 28 funded community service organisations, including Aboriginal-led organisations, were provided with an extra $11,000 per organisation to support the young people. And that funding helped families purchase technology to help children and young people participate in virtual education. So over the last 2 years, Youth Justice has also highlighted the incredible expertise and professionalism of their youth justice staff, and I want to thank them for all of their efforts. The management of COVID-19 in custody has been a global challenge, with jurisdictions all around the world and this country struggling to contain its spread. And it's a testament to their efforts that as of 1 March, we have no active cases of COVID-19 in custody and 1 in the community, and I think that's an amazing outcome. There's been an around-the-clock effort, and their care and professionalism in undertaking this rapid logistical exercise just must be commended. So the youth justice can flexibly and appropriately manage the safety and well-being of young people under youth justice community supervision by allowing young people a remote means to safely suffice the requirements of their community orders amid COVID-19. So these amendments are needed and will help our justice system, and have been consulted and are good policy. And of course, again, this extension is just a temporary extension, and that's what we need to stress. I support this bill, and I commend this bill to the House.